I'm very proud to be here today speaking in support of historic legislation that will move us one step closer to the day when who you love has absolutely nothing to do with the rights that you are afforded as a citizen of the greatest country in the world. Frankly, the passage of the Employment Non-Discrimination Act is embarrassingly long overdue. In my state of Connecticut, we've had anti-discrimination laws on the books for over 20 years. In 1991, Connecticut actually became the fourth state to formally protect LGBT workplace rights, and in 2011, we became the 15th state to offer similar protections to our transgendered citizens. So it's funny because my constituents assume that, frankly, all across this country, it's already illegal to fire somebody for who they love and for who they are. But of course, as we know, that's just not the case across most of this country. Right now, in some states, you can be fired from your job simply because of having a little photograph of your partner on your desk at work. And while ENDA has been a commonly accepted civil rights protection in my state, you may hear some express opposition to this legislation on this floor by very vaguely citing what are commonly referred to as the concerns of the business community. I'm not sure what businesses they're referring to, because in my state, we've got some of the biggest and most successful multi-state and multinational businesses in the world. And they know that non-discrimination isn't just the right thing to do, it's also really good for business. Companies like United Technologies and General Electric and Xerox, they want the best and the brightest people to work in an inclusive team environment, not having their employees hiding from each other who they really are. Companies like BI Pharmaceuticals and Aetna, they haven't folded under the weight of having these state-based workplace protections. In fact, they are thriving in Connecticut, across the country, and all across the world. And so in speaking with companies from all over Connecticut, none, to me, have ever argued that equal protection in Connecticut is something that is holding their businesses back. And frankly, they've been living under this law for decades now. And it's not just Connecticut's largest employers. Connecticut's law actually goes further than ENDA does in prohibiting discrimination even amongst businesses with fewer than 15 employees. Our small business community understands that far from inhibiting commerce, non-discrimination policies actually help make our companies, big and small, stronger. So even though a majority of American businesses oppose employment discrimination, some argue that this legislation is going to harm businesses whose leaders have very strong religious beliefs. However, I think it's important to note, Mr. President, that the religious exemption in this legislation is even broader, remarkably broader, I would argue, than that exemption that's in Title VII of the Civil Rights Act. And it represents, frankly, a compromise that doesn't go as far as some members of this body, including myself, would like. In an op-ed that was published this summer, former head of the NAACP, Julian Bond, equated these religious concerns with the arguments that he heard from opponents of the civil rights movement in the 1960s. Here's what Bond wrote. He said, quote, "In response to the historic gains of the civil rights movement in the 1960s, opponents argued that their religious beliefs prohibited integration. To be true to their religious beliefs, they argued, they couldn't serve African Americans in their restaurants or accept interracial marriages." Now, it would be shocking to hear somebody make a similar argument today about the treatments of African Americans in our society. And frankly, I think it'll be just as shocking 40 or 50 years from now for people to read that that argument is being made today about the treatment of LGBT Americans. There are, in fact, interesting to point out, numerous Christian and Jewish organizations and denominations that have taken a strong stand in favor of this legislation because they understand that unequal treatment under the law is at odds with their faith. Now, others on this floor have argued and have made the argument that passage of ENDA will lead to frivolous lawsuits from fired workers. So let me give you my state's perspective on this. Again, we've been living under this law since 1991. We've had protections that we're debating today for 2 decades, and we simply haven't seen frivolous lawsuits. And again, we have big companies that employ thousands of people across the state and across the nation. Let me just give you the statistic from 2009 to 2010, which is the most recent year that we have data available. Out of a total of 1,740 employment-based discrimination complaints that were filed in the state that year, only 53 were based on sexual orientation discrimination. As just a means of comparison, 464 complaints were filed based on age discrimination. We went back a number of years, not a single year over the last half a decade that we looked at in which there were more than about 40 or 50 complaints. My state has been a test case for these protections for sexual orientation and gender identity. The parade of horrible consequences that opponents of this bill say will happen just have not happened in Connecticut. And what we're doing here really is pretty simple. We're not trampling on the First Amendment. We're not dictating morality. We're not harming the economy. We're not undermining the religious community. We're just saying that you can't discriminate against people in the workplace because of who they choose to love or who they are inside. The simplicity of this bill is why 2/3 of the American public support it. And it's why I think that 50 years from now, history is going to judge no less harshly those that vote against this act as it judges now those that voted against some of the civil rights acts of the 50s and 60s. Who you love, who you are inside, what you feel should never, ever be a reason for discrimination. Mr. President, I was on the House floor 6 years ago when the House passed ENDA, and I still remember listening to Congressman Barney Frank's closing argument. He welled up as he was giving it, and there were a lot of tears shed on the floor as well. And I just want to close by quoting what he said. Congressman Frank said this, and I won't try to do his accent. He said, "I used to be someone subject to this prejudice. And through luck and circumstance, I got to be a big shot. I am now above that prejudice. But I feel an obligation to 15-year-olds dreading to go to school because of the torment that they endure, to people who fear that they will lose their job at a gas station if somebody finds out who they love. I feel an obligation to use the status that I have been lucky enough to get to help them. And I make a personal appeal to my colleagues. Please don't turn your back on them." We're all big shots here. We've been lucky enough to get elected to the greatest deliberative body in the world. And there is an obligation and a responsibility that comes with the job that we have here to stick up for people who are being discriminated against because of who they are. The greatest moments of this body have been when we have joined together, Republican and Democrat, to stand against that kind of discrimination. And our ability to rise to Congressman Frank's challenge, please don't turn your back on them, can be, this week, another great chapter in the history of this great body. I yield back the floor.